Oh, shoot.
I didn't have to turn it on then.
Well, good freaking day. Ladies and gentlemen, how y'all doing today?
Hello.
We're coming back to you with another Mississippi law. That's just a bill that's just been passed.
It was passed Thursday.
Yeah, it passed
22nd.
Thursday.
April
And Thursday
22nd.
ain't even a week ago. They just recently passed. Okay? It was
Yes.
just recently passed. Now,
It was signed by our Governor Tate Reeves.
one term date. Anyway,
It is called the Mississippi SB 2795, or the bill title Mississippi Earned Parole Eligibility Act. And let me tell you something, everybody, it is long. Okay. Section 1 is just the name. Section 2. Section 47-7-3 Mississippi Code of 1972 is amended as follows. 47-7-3 1. Every prisoner who has been convicted of any offense against the state of Mississippi and is confined in the execution of a judgment of such conviction in the Mississippi Department of Corrections for a definite term or terms of 1 year or over, or for the term of his or her natural life, whose record of conduct shows that such prisoner has observed the rules of the department and who has served the minimum requirement time for parole eligibility, may be released on parole as set forth herein. A. Habitual offenders, except as provided by sections 99-19-81 through 99-19-87. No person sentenced as a confirmed and habitual criminal shall be eligible for parole.
I don't know what habitual is, but
That means one that keeps committing a crime over and over and over again and keeps getting convicted. They keep getting arrested for a crime.
how does our local government how do they keep getting away with that if they habitual offenders?
It can be something minor, like one time it could be driving without no license, or another time it could be, let's see, robbery. Another time it could be, well, I say robbery without a weapon, a non-violent offense, or it could be any type of thing that they could be arrested for, and they may not have gone to trial yet, but yet they've been arrested for it, or it's
You
something
know what
minor.
we call habitual offenders, the way you just describe it, that's repeat offenders. Why didn't they just put repeat?
Yeah,
Repeat, freaking repeat offenders.
yeah, and
I mean,
I actually went through and read sections 99-19-81 through 99-19-87. It can get you a little confused. All these subsections in here. Yeah. B. Sex offenders. any person who has been sentenced for a sex offense as defined in section 45-33-23H shall not be released on parole except for a person under the age of 19 who has been convicted under section 97-3-67.
Okay, that whole sex offender thing right there just confused the hell out of me. So sex offenders can't go for it unless they're under the age of 19? What the hell is wrong with you, Mississippi? That don't make any sense. What's good for one is good for the others.
Okay. C. Capital offenders. No person sentenced for the following offenses shall be eligible for parole. 1. Capital murder committed on or after July 1st, 1994, as defined in section 97-3-19, sub 2. 2. Any offense to which an offender is sentenced to life imprisonment under the provisions of section 99-19-101. Or 3. Any offense to which an offender is sentenced to life imprisonment without eligibility for parole under the provisions of section 99-19-101, whose crime was committed on or after July 1st, 1994.
Oh, so that means anything before 94 doesn't count anymore? What do they call that stuff whenever time runs out to do something and you can no longer get anybody, you can no longer do anything? Statute of limitations?
Yes, statute of limitations.
Then, so statute of limitations runs out before 94. July 1st, as a matter of fact.
D. Murder. No person sentenced for murder in the first degree whose crime was committed on or after June 30th, 1995, or murder in the second degree as defined in section 97-3-19 shall be eligible for parole.
Okay, that up there was murder, but then this right here is murder. Okay, y'all completely
Okay.
screwed that whole thing up.
One is capital murder.
Murder's murder.
I forgot to...
You only have the degrees, first degree and second degree. But they're both murders. So capital murder before July 1st is 94. And then it says murder.
I'll have to...
First degree. Is that that's June 30th of 95.
Yeah, we'll have to come back and separate what capital murder is from first degree and all that.
I mean, I think B. Tatum already got some of that stuff. Maybe it was just for the states that he was doing.
Okay. E. Human trafficking. No person sentenced for human trafficking as defined in section 97-3-54.1 whose crime was committed on or after July 1st, 2014 shall be eligible for parole.
Okay, so human lives aren't important now?
Well, I don't think
That-
they started prosecuting human trafficking until recently.
Human trafficking's been around for a long time.
Yes,
Everywhere.
but I don't think it was really prosecuted by the state. I think it was mostly a federal offense because it crossed state lines. They allowed Uncle Sam or the federal government.
You can get people that don't even have to leave the state.
But usually it is crossing state lines, so they used to let Uncle Sam or the federal government prosecute it. But now the state of Mississippi does prosecute human trafficking.
Oh, I hope their judgment is spot the hell on.
Okay. Drug trafficking. Drug trafficking. No person sentenced for trafficking and aggravated trafficking, as defined in Section 41-29-139, subsection L through subsection G, shall be eligible for parole. Okay. G. Offenses specifically prohibiting parole release. No person shall be eligible for parole who is convicted of any offense that specifically prohibits parole release. Subsection H, I. They have this labeled weird.
It tells you how much they know about this crap that they're putting into law, but go ahead.
Offenders eligible for parole consideration for offenses committed after June 30th, 1995, except as provided in paragraphs A through G of this subsection. Offenders may be considered eligible for parole release as follows. 1. Nonviolent crimes. All persons sentenced for a nonviolent offense shall be eligible for parole only after they have served 25% or 10 years, whichever is less of the sentence or sentences imposed by the trial court. For purposes of this paragraph, nonviolent crime means a felony not designated as a crime of violence in Section 97-3-2.
I'm just
Okay, nonviolent crime.
I'm just trying. I know the difference between violent and non-violent.
Well, also
it's the difference between a weapon, between let's just say a knife or a firearm, and then these deadly weapons right here. Non-violent. You can do stuff with your hands that will make people surrender to you. You don't have to beat the hell out of them. There's so many things that you can do about this without actually harming them.
Okay. 2. Violent crimes. A person who is sentenced for a violent offense as defined in Section 97-3-2, except robbery with a deadly weapon as defined in Section 97-3-79, drive-by shooting as defined in Section 97-3-109, and carjacking as defined in Section 97-3-117 shall be eligible for parole only after having served 50% or 20 years, whichever is less of the sentence or sentences imposed by the trial court. Those persons sentenced for robbery with a deadly weapon as defined in Sections 97-3-79, drive-by shooting as defined in Section 97-3-109, and carjacking as defined in Section 97-3-117 shall be eligible for parole only having served 60% or 25 years, whichever is less of the sentence or sentences imposed by the trial court.
Okay, I'm noticing a pattern here with the whichever is less. We want people to understand that their crimes were wrong. We need to make them understand that it was wrong, and once it actually gets into their heads, then, because a lot of people, they go in, and they never learn their lesson, and then it turns into that repeat offense bull. So we gotta whichever's less. That's a joke.
3. Nonviolent and non-habitual drug offenses. A person who has been sentenced to a drug offense pursuant to Section 41-29-139 subsection A through subsection D, whose crime was committed after June 30th, 1995, shall be eligible for parole only after he has served 25% or 10 years, whichever is less, of the sentence or sentences imposed.
Oh, we got a lot to go through.
Parole hearing required. All persons eligible for parole under subparagraph I of the paragraph subsection H who are serving a sentence or sentences for a crime of violence as defined in Section 97-3-2 shall be required to have a parole hearing before the parole board pursuant to Section 47-7-17 prior to parole release. Subsection asterisk 3. Geriatric parole. Notwithstanding the provisions in subsection I of this paragraph, subsection H, a person serving a sentence who has reached the age of 60 or older and who has served no less than 10 years of the sentence or sentences imposed by the trial court shall be eligible for parole. Any persons eligible for parole under this subparagraph 3 shall be required to have a parole hearing before the board prior to parole release. No inmate shall be eligible for parole under this subparagraph 3 of this paragraph H if 1. The inmate is sentenced as a habitual offender under sections 99-19-81 through 99-19-87. 2. The inmate is sentenced for a crime of violence under sections 97-3-2. 3. The inmate is sentenced for an offense that specifically prohibits parole release. 4. The inmate is sentenced for trafficking in controlled substances under sections 41-29-139 subsection L. 5. The inmate is sentenced for a sex crime. Or 6. The inmate has not served 1/4 of the sentence imposed by the court. Subsection 4. Parole consideration as authorized by the trial court. Notwithstanding the provisions of paragraph A of this subsection, any offender who has not committed a crime of violence under section 97-3-2 and has served 25% or more of his sentence may be paroled by the state parole board if, after the sentencing judge, or if the sentencing judge is retired, disabled, or incapacitated, the senior circuit judge authorizes the offender to be eligible for parole consideration.
See, that's how a lot of stuff starts. sorry to cut you off, but that's how a lot of this bull crap starts right here.
Or if the senior circuit judge must be recused, another circuit judge of the same district or a senior status judge may hear and decide the matter. A petition for parole eligibility consideration pursuant to this paragraph 4 shall be filed in the original criminal cause or causes, and the offender shall serve an executed copy of the petition on the district attorney. The court may, in its discretion, require the district attorney to respond to the petition.
Oh my Lord!
Yeah.
This is how they said that if it was incapacitated or something happened to the judge for the original deal, and you get another one and another one. I mean, you keep going like that, you're gonna find that one bad one out of the whole deal that's gonna ruin it all. You're gonna find a corrupt one there eventually. You're gonna find a complete biased one. That kind of like what happened up there in Minnesota. That judge and all them other people in the jury must have been scared of BLM to do that. That's what I'm talking about. They're completely biased. Instead of going through and hearing everything that's going on, they're completely biased. They pick one or the other and they go with it. But
Subsection 2. The state parole board shall, by rules and regulations, establish a method of determining a tentative parole hearing date for each eligible offender taken into the custody of the Department of Corrections. The tentative parole hearing date shall be determined within 90 days after the department has assumed custody of the offender, except as provided in the Section 47-7-18. The parole hearing date shall occur when the offender is within 30 days of the month of his parole eligibility date. Any parole eligibility date shall not be earlier than as required in this section. Subsection 3. Notwithstanding any other provision of law, an inmate shall not be eligible to receive earned time, good time, or any other administrative reduction of time which shall reduce the time necessary to be served for parole eligibility as provided in subsection 1 of this section. 4. Any inmate within 48 months of his parole eligibility date and who meets the criteria established by the classification board shall receive priority for placement in any educational development and job training programs that are part of his or her parole case plan. Any inmate refusing to participate in an educational development or job training program, including but not limited to programs required as part of the case plan, shall be in jeopardy of non-compliance with the case plan and may be denied parole. 5. In addition to other requirements, if an offender is convicted of a drug or driving under the influence felony, the offender must complete a drug and alcohol rehabilitation program prior to parole, or the offender shall be required to complete a post-release drug and alcohol program as a condition of parole. 6. Except as provided in a subsection 1, subsection A through subsection H of this section, all other persons shall be eligible for parole after serving 25% of the sentence or sentences imposed by the trial court, or if sentenced to 30 years or more after serving 10 years of the sentence or sentences imposed by the trial court. 7. The Corrections and Criminal Justice Oversight Task Force, established in Section 47-5-6, shall develop and submit recommendations to the governor and to the legislature annually on and or before December 1st concerning issues relating to juvenile and habitual offender parole reform, and to review and monitor the implementation of Senate Bill number 2795-2021 regular session. 8. The amendments contained in this act shall apply retroactively from and after July 1st, 1995. 9. Notwithstanding provisions to the contrary in this section, a person who was sentenced before the effective date of this act may be considered for parole if the person's sentence would have been parole eligible before the date on which this act becomes effective. 10. This section shall stand repealed on July 1st, 2024. Section 3. Section 47-7-3.1 Mississippi Code of 1972 is amended as follows. 47-7-3.1 subsection 1. In consultation with the parole board, the department shall develop a case plan for all parole eligible inmates to guide an inmate's rehabilitation while in the department's custody and to reduce the likelihood of recidivism after release. 2. Subsection 2. The case plan shall include but not be limited to subsection A, programming and treatment requirements based on the results of a risk and needs assessment. Subsection B. Any programming or treatment requirements contained in the sentencing order, and subsection C. General behavior requirements in accordance with the rules and policies of the department. 3. With respect to parole eligible inmates admitted to the department's custody on or after July 1st, 2021, the department shall complete the case plan within 90 days of admission. With respect to the parole eligible inmates admitted to the department's custody before July 1st, 2021, the department shall complete the case plan by January 1st, 2022. Subsection 4. The department shall provide the inmate with a written copy of the case plan, and the inmate's caseworker shall explain the conditions set forth in the case plan. Subsection A. Within 90 days of admission, the caseworker shall notify the inmate of their parole eligibility date as calculated in accordance with Section 47-3-3, subsection 3. Subsection B. At the time a parole eligible inmate receives the case plan, the department shall send the case plan to the parole board for approval. Subsection 5. With respect to parole eligible inmates admitted to the department's custody after July 1st, 2021, the department shall ensure that the case plan is achievable prior to the inmate's parole eligibility date. With respect to the parole eligible inmates admitted to the department's custody before July 1st, 2021, the department shall, to the extent possible, ensure that the case plan is achievable prior to the inmate's parole eligibility date or the next parole hearing date or date of release, whichever is sooner. Subsection 6. The caseworker shall meet with the inmate every 8 weeks from the date of the offender received the case plan to review the inmate's case plan progress. Subsection 7. Every 4 months, the department shall electronically submit a progress report on each parole eligible inmate's case plan to the parole board. The board may meet to review an inmate's case plan and may provide written input to the caseworker on the inmate's progress toward completion of the case plan. Subsection 8. The parole board shall provide semi-annually to the oversight task force the number of parole hearings held, the number of prisoners released to parole without a hearing, and the number of parolees released after a hearing. Subsection 9. If the Department of Corrections fails to adequately provide opportunity and access for the completion of such case plans, the Department of Corrections shall, to the extent possible, contract with regional jail facilities that offer educational development and job training programs to facilitate the fulfillment of the case plans of parole eligible inmates. Section 4. Section 47-3-3.2 Mississippi Code of 1972 is amended as follows. 47-7-3.2 subsection 1, notwithstanding section 47-5-138, 47-5-139, 47-5-138.1, or 47-5-142, no person convicted of a criminal offense on or after July 1st, 2014 shall be released by the department until he or she has served no less than the percentage of the sentence or sentences imposed by the court as set forth below. Subsection A. 25% or 10 years, whichever is less, for a nonviolent crime. Subsection B. 50% or 20 years, whichever is less, for a crime of violence pursuant to Section 97-3-2, except for robbery with a deadly weapon as defined in Section 97-3-79, drive-by shooting as defined in Section 97-3-109, or carjacking as defined in Section 97-3-117. Subsection C. 60% or 25 years, whichever is less, for robbery with a deadly weapon as defined in Sections 97-3-79, drive-by shooting as defined in Section 97-3-109, or carjacking as defined in Section 97-3-117. Subsection 2. This section shall not apply to Subsection A. Offenders sentenced to life imprisonment. Subsection B. Offenders convicted as habitual offenders pursuant to Sections 99-19-81 through 99-19-87. Subsection C. Offenders serving a sentence for a sex offense, or Subsection D. Offenders serving a sentence for trafficking pursuant to Sections 41-29-139, Subsection F. Section 5. Section 47-7-5 Mississippi Code of 1972 is amended as follows. The State Parole Board created under former Section 47-7-5 is hereby created, continued, and reconstituted, and shall be composed of 5 members. The Governor shall appoint the members with the advice and consent of the Senate. All terms shall be at the will and pleasure of the Governor. Any vacancy shall be fulfilled by the Governor with the advice and consent of the Senate. The Governor shall appoint a chairman of the board. Subsection 2. Any person who is appointed to serve on the board shall possess at least a bachelor's degree or a high school diploma and 4 years work experience. Each member shall devote his full time to the duties of his office and shall not engage in any other business or profession or hold any other public office. A member shall receive compensation or per diem in addition to his salary. Each member shall keep such hours and work days as are required of full-time state employees under Sections 25-1-98. Individuals shall be appointed to serve on the board without reference to their political affiliations. Each board member, including the chairman, may be reimbursed for actual and necessary expenses as authorized by Sections 25-3-41. Each member of the board shall complete annual training developed based on guidance from the National Institute of Corrections, the Association of Paroling Authorities International, or the American Probation and Parole Association. Each first-time appointee of the board shall, within 60 days of appointment or as soon as practical, complete training for first-time parole board members developed in consideration of information from National Institute of Corrections, the Association of Paroling Authorities International, or the American Probation and Parole Association. Subsection 3. The board shall have exclusive responsibility for the granting of parole as provided by sections 47-7-3 and 47-7-17, and shall have exclusive authority for revocation of the same. The board shall have exclusive responsibility for investigating clemency recommendations on request of the governor. Subsection 4. The board, its members, and staff shall be immune from civil liability for any official acts taken in good faith and in exercise of the board's legitimate governmental authority. Subsection 5. The budget of the board shall be funded through a separate line item within the general appropriation bill for the support and maintenance of the department. Employees of the department which are employed by or assigned to the board shall work under the guidance and supervision of the board. There shall be an executive secretary to the board who shall be responsible for all administrative and general accounting duties related to the board. The executive secretary shall keep and preserve all records and papers pertaining to the board. Subsection 6. The board shall have no authority or responsibility for supervision of offenders granted a release for any reason, including but not limited to probation, parole, or executive clemency, or other offenders requiring the same through interstate compact agreements. The supervision shall be provided exclusively by the staff of the Division of Community Corrections of the Department. Subsection 7A. The parole board is authorized to select and place offenders in the electronic monitoring program under the conditions and criteria imposed by the parole board. The conditions, restrictions, and requirements of sections 47-7-17 and sections 47-5, 1001 through 47-5-1015 shall apply to the parole board and any offender placed in an electronic monitoring program by the parole board. Subsection B. Any offender placed in an electronic monitoring program under this subsection shall pay the program fee provided in section 47-5-1013. The program fees shall be deposited in the special fund created in section 47-5-1007. Subsection C. The department shall have absolute immunity from liability for any injury resulting from a determination by the parole board that an offender be placed in an electronic monitoring program. Subsection 8A. The parole board shall maintain a central registry of paroled inmates. The parole board shall place the following information on the registry: name, address, photograph, crime for which parole, the date of the end of parole, or flat time date, and other information deemed necessary. The parole board shall immediately remove information on a parolee at the end of his parole or flat time date. Subsection B. When a person is placed on parole, the parole board shall inform the parolee of the duty to report to the parole officer any change in address 10 days before changing address. Subsection C. The parole board shall utilize an internet website or other electronic means to release or publish the information. Subsection D. Records maintained on the registry shall be open to law enforcement agencies and the public and shall be available no later than July 1st, 2003. Subsection 9. Affirmative vote of at least 4 members of the parole board shall be required to grant parole to an inmate convicted of capital murder or a sex crime. Subsection 10. This section shall stand repealed on July 1st, 2022. Section 6. Section 47-7-15 Mississippi Code of 1972 is amended as follows. 47-7-15 The board shall adopt an official seal of which the court shall take judicial notice. Decisions of the board shall be made by majority vote, except as provided in section 47-7-5 subsection 9. The board shall keep a record of its acts and shall notify each institution of its decisions relating to the person who are or have been confined therein at the close of each fiscal year. The board shall submit to the governor and to the legislature a report with statistical and other data of its work. Section 7. Section 47-7-17 Mississippi Code of 1972 is amended as follows. 47-7-17 subsection 1. Within 1 year after his admission and at such intervals thereafter as it may determine, the board shall secure and consider all pertinent information regarding each offender except any under sentence of death or otherwise eligible for parole, including the circumstances of his offense, his previous social history, his previous criminal record, including any records of law enforcement agencies or of a youth court regarding that offender's juvenile criminal history, his conduct, employment, and attitude while in the custody of the department. The case plan created to prepare the offender for parole, and the reports of such physical and mental examinations as have been made. The board shall furnish at least 3 months' written notice to each such offender of the date on which he is eligible for parole. Subsection 2. Except as provided in section 47-7-18, the board shall require a parole-eligible offender to have a hearing as required in this chapter before the board and to be interviewed. The hearing shall be held no later than 30 days prior to the month of eligibility. No application for parole of a person convicted of a capital offense shall be considered by the board unless and until notice of the filing of such application shall have been published at least once a week for 2 weeks in a newspaper published in or having general circulation in the county in which the crime was committed. The board shall, within 30 days prior to the scheduled hearing, also give notice of the filing of the application for parole to the victim of the offense for which the prisoner is incarcerated and being considered for parole, or in the case of the offense be homicide, a designee of the immediate family of the victim, provided the victim or designated family member has furnished in writing a current address to the board for such purpose. The victim or designated family member shall be provided an opportunity to be heard by the board before the board makes a decision regarding release on parole. The board shall consider whether any restitution ordered has been paid in full. Parole release shall, at the hearing, be ordered only for the best interests of society, not as an award of clemency. It shall not be considered to be the reduction of a sentence or pardon. An offender shall be placed on parole only when arrangements have been made for his proper employment or for his maintenance and care, and when the board believes that he is able and willing to fulfill the obligations of a law-abiding citizen. When the board determines that the offender will need transitional housing upon release in order to improve the likelihood of the offender becoming a law-abiding citizen, the board may parole the offender with the condition that the inmate spends no more than 6 months in a transitional reentry center. At least 15 days prior to the release of an offender on parole, the Director of Records of the Department shall give the written notice which is required pursuant to Section 47-5 177, every offender while on parole shall remain in the legal custody of the department from which he was released and shall be amendable to the orders of the board. Upon determination by the board that an offender is eligible for the release by parole, notice shall also be given within at least 15 days before release by the board to the victim of the offense or the victim's family as indicated above regarding the date when the offender's release shall occur, provided a current address of the victim or the victim's family member has been furnished in writing to the board for such purpose. Subsection 3. Failure to provide notice to the victim or the victim's family member of the filing of the application for parole or any decision made by the board regarding parole shall not constitute grounds for vacating an otherwise lawful parole determination, nor shall it create any right or liability civilly or criminally against the board or any member thereof. Subsection 4. A letter of protest against granting an offender parole shall not be treated as the conclusive and only reason for not granting parole. Subsection 5. The board may adopt such other rules not inconsistent with the law as it may deem proper or necessary with respect to the eligibility of offenders for parole. The conduct of parole hearings or conditions to be imposed upon parolees, including a condition that the parolee submit as provided in section 47-5-601 to any type of breath, saliva, or urine chemical analysis test, the purpose of which is to detect the possible presence of alcohol or a substance prohibited or controlled by any law of the state of Mississippi or the United States. The board shall have the authority to adopt rules related to the placement of certain offenders on unsupervised parole and for the operation of transitional reentry centers. However, in no case shall an offender be placed on unsupervised parole before he has served a minimum of 50% of the period of supervised parole. Section 8. Section 47-7-18 Mississippi Code of 1972 is amended as follows. 47-7-18 subsection 1. No inmate convicted of sex offense as defined by section 47-33-23 subsection H. A crime of violence as defined by section 97-3-2 or both, nor an inmate who is eligible for geriatric parole shall be released on parole without a hearing before the parole board as required by section 47-7-17. All other inmates eligible for parole pursuant to section 47-7-3 shall be released from incarceration to parole supervision on the inmate's parole eligibility date without a hearing before the board if A. The inmate has met the requirements of the parole case established pursuant to section 47-7-3.1. B. A victim of the offense has not requested the board conduct a hearing. C. The inmate has not received a serious or major violation report within the past 6 months. D. The inmate has agreed to the conditions of supervision. And E. The inmate has a discharge plan approved by the board. Subsection 2. At least 30 days prior to an inmate's parole eligibility date, the department shall notify the board in writing of the inmate's compliance or non-compliance with the case plan. If an inmate fails to meet a requirement of the case plan prior to the parole eligibility date, he or she shall have a hearing before the board to determine if completion of the case plan can occur while in the community. Subsection 3. Any inmate for whom there is insufficient information for the department to determine compliance with the case plan shall have a hearing with the board. Subsection 4. A hearing shall be held with the board if requested by the victim following notification of the inmate's parole release dates pursuant to Section 47-7-17. Subsection 5. A hearing shall be held by the board if a law enforcement official from the community to which the inmate will return contacts the board or the department and requests a hearing to consider information relevant to public safety risks posed by the inmate if paroled at the initial parole eligibility date. The law enforcement official shall submit an explanation documenting these concerns for the board to consider. Subsection 6. If a parole hearing is held, the board may determine the inmate has sufficiently complied with the case plan or that the incomplete case plan is not the fault of the inmate and that granting parole is not incompatible with public safety. The board may then parole the inmate with appropriate conditions. If the board determines that the inmate has sufficiently complied with the case plan, but the discharge plan indicates that the inmate does not have appropriate housing, immediately upon release, the board may parole the inmate to a transitional reentry center with the condition that the inmate spends no more than 6 months in the center. If the board determines that the inmate has not substantively complied with the requirement of the case, it may deny parole. If the board denies parole, the board may schedule a subsequent parole hearing, and if a new day is scheduled, the board shall identify the corrective action the inmate will need to take in order to be granted parole. Any inmate not released at the time of the inmate's initial parole date shall have a parole hearing at least every year. Section 9. This act shall take effect and be enforced from and after July 1st, 2021.
Good Lord, there's a lot of things where it's like some of this stuff is counteracting other things, and this is what happens every time a bill comes out. They make them so freaking long. They put so much crap in there, and they got counters.
I don't think sex offenders and murderers should get a decrease in sentencing.
No, they shouldn't.
But
if you are found guilty of the crime and everything.
But a lot of people are going, there needs to be a second chance. Now, for some of the drug charges, yeah, if it's for personal use.
Drug and non-violent, other than sex offenders.
Yeah. Well, to me, sex offenders is violent.
That's what
because it's harming.
Violent.
It's harming somebody else. But a lot of people see this as a good thing. They're talking about, oh, this person or this family member is going to be able to get out now. Your family member did something bad to get in there to begin with.
Exactly. It's kind of like a certain family member of mine who was accused of messing around with it. I think she was 13 or 14-year-old, texting back and forth. It was a neighbor. That's just what got his ass put in there the first time.
But here's the thing. Murder. Or if you attack someone just to steal their car and the person that you attacked is severely harmed, yes, you should go to prison for at least 5 to 10 years at least, and you should serve the full time. I don't care what.
Because how they kept saying whichever comes first, this and that and that and that. Depending on how severe it was, certain things should be no less than 50% of everything.
Now, there are some times where, okay, if you're defending, okay, let's say you were being attacked, or I was being, well, it's me. Let's say I was being attacked. You wasn't here. I was home alone with Joel, and I was being attacked, and I killed my attacker. I was defending myself, and I killed my attacker. Um, they could they could charge me for killing the attacker, but it would be extenuating circumstances. I was defending myself.
It seems like a lot of things nowadays, they don't care about that. If there's no video, audio, any kind of proof of that stuff right there, your ass is gone.
Yeah, but in certain cases where I think in those types of situations where somebody's life was endangered and they killed somebody that way, then I think it could maybe be reduced if they were charged with manslaughter
Yeah,
or something like that. Then yes, be reduced that.
it's
But if the person just went out there and just killed somebody just for the heck of it, or
yeah
just
that
to
person full time, no eligibility. Period.
or they killed somebody just to steal a car, or steal a watch or a necklace, or just take somebody's wallet or purse, then yes, I think they should stay in prison for the full enchilada, the full sentence. But where I actually looked up this, you can actually look up these bills online and read the whole thing. And I was reading where people were saying that this is a good thing, where how that they were happy for it, and they were happy about how some of them, where it was sex offenders, were going to be getting out on some of this, and it's like not good.
Because people have lost their backbone. There ain't nobody with a backbone anymore.
Here's my issue. Responsibility has to be taken. Do I think some people can change the way from going down the road of being a full blown or staying a full blown criminal? Yes, I think they can. But most will not. They're going to keep doing it. They're going to keep raping. They're going to keep molesting. They're going to keep killing. They're they're going to keep causing harm.
So many people turn out. They didn't have a record before that, but they got something get thrown in, and then afterwards they start becoming repeat offenders, even after being in there for a short amount of time. Say a lot of people they go into prison after so many years. They're what was that institutionalized.
well,
They're gonna do something to get thrown back in.
well,
Because it's the
here's the
only
thing.
life that they know at that point.
Yeah, but here's the thing. I think if it's personal use of drugs, I don't think they should go to prison per se. Maybe county jail for a couple of months, and then have to get out, get a job, go to drug court. Is it drug court? And go drug program. But if they're selling the stuff, then yes, go to prison. I'm talking not selling small amounts. I'm talking selling. Well,
You're still
yeah,
dealing regardless.
yeah,
Little here, little there, no big deal. Meanwhile, them cartel and all these other people here in America wanting to make something of themselves. They claim they're making something of themselves.
but if
They're
you
wanting to be the next damn. Uh,
but here's also the thing: if you're gonna sell it to children, you definitely need to go to prison.
Do you think the people that's wheeling and dealing the drugs cares how old the people are they're selling it to? No. As long as they're getting the money for it, they'll sell it to anybody.
Oh crap! Then you can't. Then it's probably you can't make an exception. Then all the drug dealers probably need to go to prison. Then sorry, I
But
was trying to make an argument that how the drug dealers shouldn't go to prison, but all the drug dealers shouldn't go to prison.
as long as they're getting money off of it, it don't matter.
But personal use. Okay, let's say you get caught. What is it called when you with the marijuana cigarette thingies? They're called something. Tokens?
Tell them
No,
joint.
joints.
You got a normal joint. I can tell you about that because I'm not just on that part right there by no means, but it's been a long time since I've done it. But what about the joint?
Well, if they have it for personal use and they get arrested for that, I don't think they should go to prison. Now, if you're the
No, it ain't no prison offense. They say if you've got X amount of it, and we're talking about a freaking I call it a brick or a kilo or you
now
know.
if you're producing the meth and stuff, yes, you should go to prison because you're
I
not.
mean, it's already a death sentence whenever you mess with crystal meth and heroin and crack cocaine. Crystal meth being the worst of all of the goddamn things. All of those damn pipe cleaners and stuff right there. You really want to put that into your system.
Well, what they're besides endangering their life. If they're have neighbors, they're endangering the neighbors too. Because if they blow up their home, they're gonna probably blow up their neighbor's house too. And then
Yeah,
the
crystal
fumes.
meth labs. Yeah, it's not just the fumes because once the walls and the roof blown out, then the fumes are just gonna go up into the air. And it'll eventually dissipate, but it kill everybody that's in that home. It
Now,
will. It has a depending on how much they got there.
I
Oh,
meant
the blast radius. I mean, hell, it's just like overheating a dad blasted water heater. I know this has nothing to do with drugs, but overheating a water heater, just a normal. What's that? About a 50 gallon water heater or so. Overheating that thing whenever it's got no water in it, that thing could explode and it could knock the wall off the back of the house here. And this thing is brick. Just imagine what those drugs and all that stuff is highly freaking toxic and flammable
yeah.
can do.
Now there are some parts of this that is actually is kind of good, but then there's a bunch of
Majority of it that I've seen.
is not. When it comes to sex offenders and murderers, that's not too good.
Uh, but it's an interesting deal.
But yeah, you can actually you're gonna have to just read it yourselves and make up your own minds on this
It's
bill.
goofy shit really is. But that's a long one.
Oh God, yes.
You already tell your voice is starting to go a little bit. So I ain't gonna make her talk too much more, y'all. And for her reading that much right there, good lord. I'd have got about a quarter of the way through and just gave up on it and said like, all right, here. I'll just try to figure out a way to upload all this stuff right here so everybody could uh, read it for themselves and try to make sense of this crap. Uh, but you did good. that being so, on that note, we're gonna get off of here. Hope this was very informal,
Informative.
informative. You know, I never did it. Is that it?
Informal is me wearing this.
Sweetheart, you got what I was saying. But yeah, we're gonna get off of here. And I hope like heck that well, I just hope it was good. And we'll catch y'all with another story. There may be another bill gonna get passed here shortly. That's just as goofy as some of the stuff that was in that bill, or any of these other bills with the contradicting. This contradicts that, and it's horrible. But anyway, we'll catch y'all later. And remember, name's Phil.
Regine.
We'll catch y'all later.